Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about class actions and data breaches. Cases that should have gone to the Supreme Court of Canada, but didn't. Uber was sued by an individual trying to launch a class action lawsuit after hackers successfully breached Uber's databases and stole confidential information that was stored in those databases. The court refused to certify a class action, determining that the class was not really identifiable and the loss would not really be quantifiable because although some people may have had their data breached, the data breach was not done as a result of any provable negligence on Uber's part, but instead as a result of a criminal act. And further, there was no way to determine how much any individual person was out because different people may have experienced losses between $0 and an unknowable amount. And so the class could not properly be determined, and because it was a criminal act as opposed to negligence, there was no civil issue to be tried. And this case raises very important issues about that question of a criminal act and what companies should be doing to prevent criminal acts from taking place. When the law of negligence was first established, we didn't have issues related to data security. And in fact, negligence law, as it relates to data security, is something that has never been considered by the Supreme Court of Canada, meaning that we have no national jurisprudence on what constitutes the appropriate measures that a company that stores people's data should be taking to protect them from hackers. We know that data is vulnerable. We know that large companies are vulnerable to attacks that try to seize data from individuals. What are the guidelines for determining whether there has been negligence on the part of those companies? Even though the test for negligence might be clear in law, as it applies specifically to data security where criminal attacks are to be expected, as opposed to the unexpected thing that you might just have insurance for, should there not be a different standard that applies to these types of attacks? And should there not be a different standard to prevent people from having their data inadvertently released and coming to harm as a result? And on the second question of whether or not there should be a class action, is it not preferable to have these data security issues determined in the context of a class action rather than potentially having thousands of individual actions, all of which make the same determinations about whether or not there was negligent conduct on the part of Uber or any other company, and then have to go through a determination about whether there was any loss as a result of that negligence and the quantification of the loss? In the circumstances, it doesn't seem to make a lot of sense for the court to have proceeded the way that it did. And the Supreme Court of Canada could have had an opportunity to really chime in on two significant issues that are really emerging and important areas of the law that are going to affect our legal system for years to come. This is not the last we're going to hear about data breaches, and this is not the first case involving data breaches, but the Supreme Court of Canada seems to want to shy away from getting involved in these cases. And unfortunately, it's going to take another case involving another serious data breach and the potential compromising of people's personal information before the Supreme Court of Canada really takes the opportunity to hear these cases. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazenville Creative for putting together these videos. Please like, subscribe, and share with your friends.